You see a red circle? Yeah, and then the red numbers. Okay.
Good morning, we're going to get started. This is a regularly scheduled meeting of Panel A at the Medical Board of California. My name is Jamie Wright, and I'm the chair. Will staff please come forward and do roll call?
Dr. Bishop?
Here.
Dr. Hawkins?
Here.
Dr. Lewis?
Present.
Mr. Serrano Sewell?
Present.
Ms. Jaroslawski? Present. Dr. Yip?
Here.
Ms. Wright?
Here.
We have a quorum.
Thank you. Joining us today is Administrative Law Judge Schneider. She is going to assist us, but before we do that, our court reporter has asked that each person on the panel please identify yourself before you speak so she can catch everyone's name because of the position that she's sitting in. Thank you. Okay, Judge Schneider.
Good morning. I'm going to be opening the record in the matter of Zachary King Cosgrove. And this is OAH number 2015-120820. Today is January 21st, and it is 10 a.m. As you know, I'm an administrative law judge from the Office of Administrative Hearings assigned to sit with the Medical Board, which is convened here today to hear our oral argument on the non-adopted proposed decision in relation to Zachary King Cosgrove. May I take the appearances of counsel for the record, please, beginning with the Attorney General.
Good morning. My name is Robert Bell. I'm supervising Deputy Attorney General, and I am here today with respect to Government Code Section 11.523.
Good morning. I'm Edward Beer on behalf of Dr. Zachary Cosgrove, who's seated here to my right.
All right. Good morning. Before we get started with oral argument, I just want to review the procedures here today and the ground rules. The arguments must be based on the existing record. No new evidence will be heard. The ALJ and any panel member may ask the party's oral argument on a matter with a specific citation to the record. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. As I think everyone is aware, the sequence of, and I will remind you, time limitations on oral arguments are as follows. First, the petitioner, 15 minutes. Second, the Deputy Attorney General, 15 minutes. Third, the petitioner's rebuttal, 5 minutes. Fourth, the Deputy Attorney General's rebuttal, 5 minutes. Additionally, I'm going to be offering Mr. Lear, your client, an opportunity to address the panel directly. Would he like to do so?
Yes.
Okay, so I'm going to invite him to do so after the Attorney General's, Deputy Attorney General's rebuttal, and he'll be given 5 minutes for that purpose. I'll be timing both of you. Do either of you wish for me to give you a 5-minute hand raise during your oral argument to let you know you've got 5 minutes left?
Sure.
Okay,
Yes,
Mr. Lear? Okay, so I will do that. Any other questions before we begin?
None.
All right, you may begin, Mr. Lear.
Thank you. Thank you to the board and Your Honor for giving us the opportunity to orally argue the issues that happened in this case. This is a case where we seek the reinstatement of Dr. Zachary Cosgrove, who was licensed as a physician by the Medical Board in 1997. He completed his residency in 2001. The gravamen of the action that caused him to surrender his license in 2008 had to do with boundary issues. And the members of the board and the court are aware of the details of those, but generally these were boundary issues that involved consensual relationships with patients of his. Dr. Cosgrove testified at the trial, and this was not refuted in any way, that he acted inappropriately. He understands that there are boundary issues that physicians must follow and that he did not follow those. Those boundary issues with the 3 patients happened in the time period of 2003 to 2006. As came through at the trial, there was a nexus between the boundary issues that he had, for which he has great remorse, as was in the record, and his use of crystal methamphetamine during that time period. There was testimony from Dr. Cosgrove about his knowledge that the use of crystal methamphetamine causes hypersexuality, and that the consensual relations in which he was inappropriately engaging were essentially caused by this hypersexuality that he had at that time period. Dr. Cosgrove has been married for 27 years. During that period, from 2003 to 2006, there was marital discord, which, amongst other things, caused there to be an open marriage situation. Since all that happened, the marriage has reconciled. His wife is here to support him, as she was at the trial as well. This is a situation where I think the most significant fact of all the facts is his date of sobriety, namely December 7th, 2006. That is unrefuted by the board. There was character evidence, there was expert evidence, there was all kinds of other evidence to show that Dr. Cosgrove no longer has an ongoing issue with drugs, alcohol, anything. He's as clean and sober as they come. And to his credit, not only is he clean and sober to make his life better than that of his family, but he's also given back to the community. So he's an active member of Narcotics Anonymous. He's an active member of other support groups in the San Antonio area, which is where he lives now. That active member doesn't just mean that he's going to the classes as he's supposed to go. It doesn't mean that he's peeing in a cup like he needs to, where he's been clean for almost 10 years now. But it also means that he's the poster child for rehabilitation. There was evidence at the trial that he's out there speaking to groups of people who are in the recovery mode. So he's giving back, he's trying to share his experiences, because the story at the trial, and as you know from reading the transcript and the briefs, is a man who was at the height of success. He had worked very hard to get through medical school, to become a doctor, to become a respected member of the community, only to fall to the demon of drugs. And that's part of the story that he tells. He has sponsees, he is very active in letting people know how far one can fall from the use of drugs. In this case, what we did in the underlying trial, and we think successfully, is we showed, one, the remorse of Dr. Cosgrove for the bad acts in which he engaged, and two, more importantly, I think to this board and to everyone, his rehabilitation. He had a bump in the road of life. It's not likely to recur, insofar as that bump was occasioned by his use of crystal methamphetamine, which caused the bad judgment. He's clean and sober since December 7th of 2006. He's been nothing but a good citizen. There have been no further issues that have occurred since his time of sobriety. And so we asked the board and the court to consider that he is rehabilitated. And to take that to greater detail, and this is outlined in the brief, we bullet pointed essentially the points of the rehabilitation. So he, Dr. Cosgrove, is treated with a psychiatrist on a regular basis since 2012, and that's Dr. Tickler. There was in the court record a letter from Dr. Tickler that essentially opines and concludes that Dr. Cosgrove is not a threat to the people of the state of California in holding a medical license. Further, there is unequivocal, unrefuted evidence that he's been clean and sober since December 7th of 2006. Further, he regularly attends Narcotics Anonymous meetings and is an active participant in his groups, having sponsored others and volunteered his time with NA. And he's been invited to speak at the regional Narcotics Anonymous conferences. He is a regular attendee at his church and is an active member of his church community. And again, there was unrefuted testimony at the trial about his involvement with his church. And of course, we had 4 character witnesses at the trial, but we're also attesting to his good character and his involvement with his church and his community. He has complied with his contract with Beck's, our County Medical Society's Physicians Health and Rehabilitation Committee. That's not anything he was forced to do. That is something that he voluntarily has engaged in, and he's successful and he's completed that. Petitioner has attended the Prim-E medical ethics course. He has attended professional boundaries ethics courses. He has attended and completed UCSD's PACE program. He has done extensive study with continuing medical education courses. And again, that was unrefuted evidence that was proffered at the underlying trial. He keeps abreast of developments in the medical field by regularly reading medical journals. And he has shadowed a number of doctors since his license was surrendered so that he can keep abreast and current as much as possible with the practice of medicine. At trial, Dr. Cosgrove testified about the passion that he has for medicine, the fact that he believes that he was born to this earth to practice medicine and to serve others. And he understands that he has no one to blame but himself for not being able to do that as we sit here today. He very humbly and respectfully asks that he be afforded that opportunity again, and we think that we met the burden that we needed to meet with respect to the evidence that we proffered at the underlying trial. Thank you.
All right, Mr. Bell?
Ladies and gentlemen, good morning. Thank you for hearing me. I have the duty and responsibility of pointing out the other side, and we'll begin by discussing what got Dr. Cosgrove in trouble in the first place, which has been described as inappropriate and consensual, but it was far from either of those things. It was much worse than that. There are 3 patients involved in the case. Dr. Cosgrove was practicing in the Bakersfield area for a clinic operation. The wealth of the individuals coming through this clinic was not great, and several of the patients were extremely vulnerable. The first in point of time occurred in 2003. The patient referred to in the accusation in the papers as patient KL. She was 27 years of age. He began a consensual, that is, he didn't club run ahead, he seduced her, sexual relationship, stayed at her apartment 2 to 3 nights per week. He smoked marijuana when visiting her. After 6 months of this or so, she reported him to the Bakersfield Police Department for assault. She got a restraining order, which he violated, which resulted in a misdemeanor charge against him, for which he served a year of probation, criminal probation. The finding in the case is that this violated Section 726, which is sexual misconduct or abuse of a patient, as well as gross negligence amounting to both the sex and the physical assault on the patient. The next case came a year or so later in 2004 with a patient YM, 35 years of age, a woman, who was suffering from borderline personality disorder, bipolar illness, and substance abuse, all of which was documented in Dr. Cosgrove's records for this patient. He well knew all this. He began by rubbing her breasts during the physical examination. She reciprocated by unbuttoning his shirt and doing the same. One thing led to another. He ended up delivering a prescription to her house at 10 in the evening, which then ensued with oral sex and a continuing sexual relationship. She threatened to report him, thinking that he had abused her on reflection, and he punched and kicked her, and she reported him to the Bakersfield Police Department. Here the finding was sexual misconduct or abuse under Section 726 and gross negligence. Finally, in 2006, we have patient TT, a 26-year-old female, who was being treated for depression, who the doctor noted in his testimony was probably borderline personality and suffered from an anxiety disorder. He offered to help her with disability paperwork. He got her cell phone number as a result. He then sent her increasingly suggestive text messages, which became explicit. They had a sexual relationship that lasted about 3 weeks, and according to the testimony, involved 4 to 5 acts of intercourse. He once came to her apartment intoxicated on alcohol and helped himself to 3 prescription Xanax of hers. She complained to his lawyer, or his employer. He then came over to her place and told her, in an attempt to dissuade her from going further with this reporting, here's the quotation, "You'd better just kill yourself. That's going to hurt less than what I'm going to do to you." The finding there was unprofessional conduct for criminal threats, also repeated negligent acts, also convicted of a crime, dissuading of a witness, and finally, possession of marijuana. Action was taken against him very promptly. He then gave up his rights to practice pending the outcome of the criminal case that was then pending against him. Finally, his license was surrendered and he lost his license. He then removed himself to Texas, where he's been for the last 6 or 7 years. He is not practicing medicine. He works in sales, including batteries of, medical devices. He'd like to get his license back here. He'd also like to get a license in Texas in one other state. He consulted an attorney. The attorney said, well, if you're going to get anything going, you've got to get your California revocation lifted. How am I going to do this? He says, well, I've got this Dr. Tickner you should see. So I went to see this Dr. Tickner, who has no particular talents based on his resume, in respect to dealing with boundary issues, and consulted with him. He saw him for an hour and a half or 2. He then sees him 15 to 20 minutes every once in a while along the line, and has during the time. Dr. Tickner did not apply any psychological testing, anything to assess his personality, and pointedly declined to put either in his medical records or in a letter that he later provided to Dr. Cosgrove for use in these proceedings, any DSM diagnosis. So we have no idea from Dr. Tickner what this person suffers from, let alone that the theory that Dr. Cosgrove is now putting forward is true. He applied once for reinstatement. It was denied by your agency on the basis of a lack of psychological understanding and rehabilitation. He has now come back a second time, a petition filed in 2014. This is not my case. I have not handled it previous to that. At this point in time, something novel happens. Dr. Cosgrove has a new theory, one never disclosed before, which is because he used crystal meth, he became disinhibited and hypersexual. This was not mentioned, this crystal meth business, from 2002 until 2014, 12 years. He came before you. He did not assert this theory in his defense at the time he was originally disciplined. And he made no mention of it whatsoever in his first petition for reinstatement. He explains that by saying he thinks that would show him in a bad light, and indeed it does. So, on examination at our hearing, whose record you have in front, I asked Dr. Cosgrove, tell me about your drug use. And it turns out that he was smoking this stuff twice a day since his 3rd year of residency. So in response essentially to the question, did you ever get intoxicated and have patient contact? Well, yes, of course. Every day, or essentially every day. There was not a day that Dr. Cosgrove worked as a doctor in California when he wasn't under the influence of methamphetamine. I asked him if it affected his judgment. He said, well, probably so. Now, if he says it affected his judgment with respect to sex, clearly it could have affected his judgment with respect to clinical care, could it not? This is a very big issue, and it causes us to be extremely dubious about the honesty of this physician coming before you. It establishes very clearly that Dr. Cosgrove is quite prepared to withhold from you information of an important nature in order to get from you what he wants, which is the return of his license. And if indeed this behavior explains what he did, can anybody answer why it wasn't put forward earlier in his defense? It is a later discovered alibi, and there is no support in science, in the record, to do this, and the administrative law judge discusses this. There is a letter which is not sworn, which is produced by a physician in Texas. He was challenged to come to the hearing. He was not produced at the hearing. He could not go through cross-examination. His demeanor could not be tested or observed. He could not be asked about why he didn't do certain diagnostic things, or even if he knows what he's talking about from a scientifically defensible standpoint, although that's what Dr. Cosgrove's case relies upon. So as a result, what we have is a person who's done some very bad things, and we don't know why he did them. On cross-examination, Dr. Cosgrove acknowledged that his hypersexuality could be caused by a variety of conditions, quite apart from methamphetamine use, including manic, schizophrenia, exposure to pornography, other mental conditions, including borderline personality disorder, which he acknowledged is a condition which can render a person impulsive, seductive, and extremely sexual. The letter from Dr. Tickner quite explicitly does not state that the petitioner's drug use was a cause, let alone the sole cause of his improper acts. There are various reasons to be dubious about this claim. First, as I've mentioned, there was no expert opinion given on this key point. His only non-expert testimony about the cause of his misconduct, that is, the doctor talking by himself, he attributes it, supported only by Dr. Tickner's ambiguous opinions and conclusions in the form of an unsworn letter. And that does not establish his burden by clear and convincing evidence. Now, whatever the sympathies of this panel may be, you are bound by law to decide the case in accordance with precedent and law. And the law of these petition cases is that rehabilitation has to be proven by clear and convincing evidence based on admissible evidence. And as the administrative law judge has pointed out in his proposed decision, and which I'm obliged to point out to you today, such evidence does not exist. So there is no principled way of deciding, oh, that explains the problem. The very cleverness of this argument is that if the drugs caused hypersexuality and loss of control, and those drugs are not being taken, QED, it couldn't happen again. In the absence of oxygen, there can be no combustion. In the absence of trees, there can be no forest fire. In the absence of methamphetamine, there can be no reoffense. But as we all know, there are those who offend against patients who have no dealings with drugs. And whether or not he used drugs may be just a confounding coincidental fact to a person who has a significant characterological difficulty or personality disorder. And cautious people have to know the facts. And going on guesswork doesn't work when we're trying to protect the public interest. If you had a solid explanation based on tested testimony that something triggered something and it's no longer part of his life, that would be an entirely different case than you have today. You don't. And I would submit to you that you'd rather be safe than sorry. We just don't know, and responsible people making responsible decisions don't go on guesswork. As pointed out, he didn't bring this out in his first case, or in his hearing, and that causes us to be dubious about it. And third, quite obviously, he's clearly disposed to manipulating the truth, disclosing to you or withholding from you those things that he thinks will motivate you to decide in favor of him or not. In summary, he simply has failed to provide the required showing of rehabilitation. He did not provide competent medical or psychiatric evidence showing his methamphetamine use caused the behavior that led to his revocation, nor did the evidence adequately address his failure to disclose for 12 years his methamphetamine use to the board. And we submit that his behavior was sufficiently egregious and ongoing that it calls for the ultimate sanction. It clearly did originally, and when you are presented, we believe, by the way, lest it be construed, we believe that people have a second chapter. We believe in the possibility of redemption and change. We're not here to say, having sinned once, we think you should be stricken from the rolls forever. No. We think that you need competent evidence to determine why this happened and that it won't happen again. And in the absence of that evidence, it would be wrong to take a leap of faith and to give this man his license back. He may come before you again with better and different evidence, and we look forward to that time. But right now, isn't there, and we call upon you to support the proposed decision and deny reinstatement this time. Thank you.
Thank you.
Thank you. There's some fundamental misstatements that were not part of the record that have been proffered just now. The biggest one is a suggestion that the crystal methamphetamine use is an alibi. That it just magically appeared at the last trial. Not the 2012 trial, but at the 2015 trial. Someone didn't do his homework. There was a motion for reconsideration at the 2012 trial where the crystal methamphetamine use was stated under declaration of penalty of perjury. Dr. Cosgrove made the board aware after the trial that he had been a user of crystal methamphetamine. That motion was denied. Mr. Bell should look at the file a little more closely. So there's not an alibi. There's not a let's pull the wool over the board's eyes and make up this crystal methamphetamine use that didn't really happen just so I can get my license back. Think about that. Would you go on record lying about having used crystal methamphetamine for a 12-year period? How does that portray you? Not in a good light. He did that at his own peril. It's true, there's no evidence that was at trial that disputes the fact that he had a drug problem. And now at the 11th hour, we're hearing from the board that this is, quote, a later discovered alibi. There's no evidence for that. That's a misstatement of fact. And the record is replete with evidence of the drug use. Then Mr. Bell, the board, tries to marginalize Dr. Tickner. I ask each of you to read Dr. Tickner's letter. Dr. Tickner is the San Antonio area doctor, psychiatrist, with whom Dr. Cosgrove has treated, continues to treat, who states in that letter unequivocally that in his belief, having treated Dr. Cosgrove does not present a threat to anyone in being reinstated as a medical doctor. And quote unquote, Dr. Tickner states in the letter, this is in the brief, it is clear that Dr. Cosgrove understands the relationship between his drug abuse history and his taking advantage of several patients in his medical care. He understands that independently and together, under no circumstances can he relapse in either area. What could be clearer than Dr. Tickner's conclusion? One, his knowledge of the drug history. He's a psychiatrist. If he knows about the drug history, he's clearly going to be dealing with that in the sessions that he has with Dr. Cosgrove. And then he opines as a psychiatric professional that Dr. Cosgrove understands and appreciates the connection between the drug abuse history and the lapses that he had in the sexual context. That was in the trial. Another thing that was not pointed out is that the medical board was aware that Dr. Tickner would present a letter, and at no time did the medical board contact Dr. Tickner. They had the opportunity to do so. They didn't do so. They didn't want to. They didn't want to. So the testimony from Dr. Tickner through his letter is unrefuted. There was no medical board expert that came in and said, Cosgrove is not psychiatrically capable of practicing medicine, or Cosgrove still has a drug problem, or Cosgrove has other manic issues. They could have requested an independent medical examination of Dr. Cosgrove in order to show that he was deficient in some way, shape, or form. They did not. We met our burden on every level. He is unequivocally rehabilitated from his drug problem, which was the nexus for the bad acts in 2003 to 2006. Yes.
Time. Thank you very much.
Thank you.
Mr. Bell.
Thank you. I'll just respond to those 2 points relatively briefly. First is that I misquoted the record and that he had previously disclosed this. No, we actually have it from Mr. Cosgrove, as he must be referred to. I don't mean any disrespect, but as you know, it's improper in law to refer to it as a revoked position by a doctor in California. So I'll call him Mr. Cosgrove as he is now. If you will refer to the record, all of which you have, you will see that there is a petition, which is Exhibit 8. Exhibit A of that is a personal statement by Dr. Cosgrove, Mr. Cosgrove, excuse me, that states on page 3, I had a secret problem with amphetamines, and more fulsomely on pages 2 and 3, the following passage, which I will read you. At the time of my last application for reinstatement, I was so ashamed and confused, I actually thought the less the board knew about me and my...
Excuse me. You're going a little too fast.
At the time of my last application for reinstatement, I was so ashamed and confused, I actually thought the less the board knew about me and my life, the better off I would be. My addiction was a secret I had been protecting for years. I kept it from my employers, my parents, most of the rest of my family, the police, my patients and community, my colleagues, and of course, the medical board. I was not ready to divulge that part and face the repercussions that might come for what I considered as shameful as anything else in my life. I was trying to save face and present my best self. Don't believe me. Believe attachment A. Mr. Cosgrove's own words. Now, with respect to the Tignan letter, it is essentially, as an evidentiary matter, fluff or lint. It was objected to in law under the Administrative Procedure Act, Section 11.523, Subdivision B. Unsworn documents of that nature may not support by themselves a finding of fact, certainly not where an objection is timely made, unless they support other admissible evidence of a technical nature on the subject, which there wasn't. There are some disturbing things, even if you do consider it for its very limited value, which the judge discusses, which includes the fact that Dr. Tignan himself does not hold himself as particularly knowledgeable in this business of drug use and hypersexuality, but did receive from Mr. Cosgrove a number of journal articles that the patient fed to him on the subject of maybe this happens. All right? He was in Dr. Tignan's office as a result of a recommendation of a lawyer who wanted him to get licensed in Texas, who knew the key to the kingdoms was through this room with you to get his California license reinstated. He sent him to a forensic specialist who he thought would do him some good. Bring him out. Costs, what, $200 or less to fly out from Texas to California on Southwestern. It was proposed to dispense with his in-person testimony. We objected, is this all right? And he was not produced. And you may draw your own conclusions of why a witness of such significance was not produced. In any event, we remain confident that you will do the right thing in supporting the administrative law judge's decision because there is an absence of information necessary in law to make a favorable decision in this case. It has to be clear and convincing evidence to a reasonable certainty. It has to be in the record. It has to be admissible. When you receive that, then your discretion is unlimited to do with you as you see fit. In the absence of that, your discretion is highly limited because he hasn't proven his case, and the law requires that he establish it according to the standards that I've just demonstrated. So thank you very much, and I look forward to your decision.
Thank you. All right, Mr. Rear, would you like to testify?
Yes, sir.
Okay, please stand. Do you solemnly raise your right hand? Do you solemnly swear or affirm under
Cosgrove. And there have been accusations against me, which I don't deny. Some of them are assumed to be true, and so I won't deny some of the details, although they are, in my mind, in question. But nevertheless, the gist of it is correct. I came through medical school, did very well. I went through residency, did very well. My whole life, I've aspired to do well and do good, and I always have. And I was never in any trouble, and I never had any psychological evidence of problems in my life. I prospered. I went through medical school and residency, and was regarded well. I had great recommendations as I finished, and I got my first job in an underprivileged clinic. I didn't aspire to get rich. I didn't aspire to, rule the medical world. I just wanted to help people, and that's the environment I chose to work in. And during that same period of time, my wife and I were having troubles, and somebody had introduced me to a stimulant drug. I used it, and it, of course, it has these effects on your brain, on your mind, and then ultimately, eventually, it changes your personality. And that's what I found had happened to me. I wasn't aware of it at the time. Being that person, you don't realize what's happening to you until retrospectively. And my behavior changed, my judgment changed, and my personality changed. And I had a lot of people who knew me before and who still know me who testified to that. And it was a while for me to realize how far I had drifted from the person I had aspired to be and had always been. By the time the medical board had looked at my first petition for readmission. It was difficult for me to see who I was coming up to that time and what were the causes of it, but having not used for several years by the time I applied, it was coming clear to me where I had come from and who I had been and what had happened and what were the causes. And at the time I was applying to the board, I admit that we didn't bring it up originally, and that was the advice of counsel. We had discussed whether or not this should be something that we should bring up, but being that it had been 6 years since I had used, and this wasn't the issue at hand, on his advice, we didn't bring it up. I was denied. Judge Astley made several points in my favor of my attitude, my character, the things I had shown as evidence for my rehabilitation. And she pointed out a couple of deficiencies, and that was that I hadn't had adequate psychiatric evaluation to prove that I was safe and I hadn't addressed my substance abuse problems. So I took that into consideration. I talked to a psychiatrist at that time who wrote a letter, and we submitted to the board for reconsideration, but it was probably a little too late, a little too late at that point. So I took Judge Astley's advice, and I sought psychiatric help for clarity in my issues, and I began to do drug testing to document that I'd been clean and there was no issues there. I involved myself in the community, I involved myself in NA, tried to just document to the board the kind of person I was. And so, I would have something to present. And subsequently, I haven't gotten in any trouble. So that was a period of time when I was ashamed of my behavior. I had gone off the rails, but I just wanted to get back on the rails. I had done so much up to that point to help people in the underserved communities of California, which are a lot of need for doctors to help. And I went off the rails. I admit that. My behavior was important. But I'm back. And super remorseful. And I know that not only have I hurt myself and my family, but I hurt the community, I hurt the medical profession. And I'd like the chance to redeem myself and help people. That's what I can do. That's what I'm trained to do. And that's really the only thing I want to do. I haven't had a lot of fulfilling opportunities or jobs since then because my focus is in the medical field. And I've concentrated my efforts to get back into the medical field so that I can do what I was brought to do. your child is successful at doing and doing well at. And that's all right. Thank you for listening.
I'm going to go to our panel members and see if they have any questions. And I actually do have one question before we begin. Mr. Bell, you say in your brief, and as well as during this hearing today, that an attorney directed Dr. Cosgrove to go to Dr. Tickner so they could do some kind of forensic something to get his license back. Can you just tell me where in the record I can identify that? Because I don't see it. I see it in your brief, but I don't see it in the record.
I wish I could make rapid reference to that. It is part of the direct testimony of the petitioner in this case.
Okay, so it isn't.
Or his cross-examination, I believe, about how he led to that. There's a reference to, I believe, in my brief to, that's the key to this. I've forgotten on what page that's on. There is a reference to that.
I saw the Indiana license, but I didn't see the attorney.
It would just be immediately received. That's footnote 3, when asked on cross-examination, so getting a license back in California may be the key. That references the advice given by the lawyer at page 160. So I would search around page 160 if I could just using that describes the relationship. See if I can find it. Let's see. All right, page 149. Beginning of line 7. Now you got to see Dr. Christopher Tickner at standing firmly for the result of the recommendation of the attorney. Is that correct?
Okay.
You see what I'm saying?
Yeah, I got you. Okay, thank you.
Dr. Hawkins, Dr. Cruz, tell us how often, what regularly did you see Dr. Tickner? In general, what happened in those sessions when you met with Dr. Tickner?
I first was recommended by an attorney in Austin who does readmissions to see a psychiatrist with regards to my issues. And I had called a different psychiatrist originally who couldn't see me. He was busy or out of town. He recommended Dr. Tickner, actually. But and there's only a few doctors in San Antonio that are qualified. And if you look at his letter, he's highly qualified. That's what he said. He's got 20 or 30 years in the field of these types of readmissions and issues and board boundary violations. The things that we did, we talked about, I gave him all of the material from the readmission and the accusation. So he was thoroughly aware of my case and the accusations. What did we talk about? We talked about my past. We talked about drug use. We talked about the effects that it has on people. We talked about rehabilitation insight. We talked about making amends. We talked about getting in touch with, like he would ask me, why did you do this? And so I had to go home and think about that. Why did I, start using drugs? And that was a deep question for me. Why does somebody start using drugs? Obviously, drugs might make you feel better at first, but why does a person choose to use them? And that was a deep question for me. How did I get to the point where I would choose to use drugs? So there was a lot of insight questions, pointed questions. He would challenge me on who I was at that time and how I might have gotten to be that person. Those types of things. And then I would come back. I would see him for up to 60 minutes sometimes, 45 minutes I'm sure, regularly. 30 to 45 minutes. I know the record it says 15 to 30 minutes, but I misspoke at that time. I think our sessions were normally 30 minutes and they would run over.
I have several questions. First is Mr. Cosgrove. Again, sort of on lines, this is Dr. Lewis. Okay. On lines again of the ongoing psychiatric care, I don't know if, I didn't hear a full answer about your current frequency with the psychiatrist. I didn't hear you
The
state frequency now.
Frequently?
Now.
We've been seeing Dr. Tickner once a month for the last more than a year, a couple of years, I think it's been since 13.
Okay. Next question deals with your demonstration of your clinical competence. I see when I read the brief from the Attorney General following the non-adopt proposed decision, a list of continuing education events, courses you've taken, and interest of time, I won't read through all of them, but can you tell me what clinical competency type of CME courses that you have currently taken, other than ethics course, boundaries course, and so forth?
There's a whole slew of them. They're not all recorded, but I think that they are submitted. There's hundreds of hours of CME, including everything from diabetes care to heart disease, to emotional issues, patient relations, all kinds of things. In addition, I went to the Scientific Assembly, which is like a 4-day course in Philadelphia a couple of years ago, which is offered by the American Academy of Family Practice. I went to a board review course. And then I've been in the clinic with my mentors, including Dr. Mullen in Texas on a regular basis for a period of time. So as far as my clinical competency, that was actually never in question up until now.
You've been out of practice of medicine for how many years?
Since my license was surrendered in February of 2008.
Okay. What is a Prim E course?
It's Prime B. I don't know exactly offhand. I think it's rehabilitation in medicine and ethics. Physicians rehabilitation, medicine and ethics, I think. It's offered by a PhD who from University of New Jersey. I forgot. It's been 5 years or something since I've been to Rutgers. They changed their name to Rutgers, but it's the same affiliation. And it's a 2-day course with interaction around a table of other physicians who have had boundary violations and reading many articles from Dr. Osler and other physicians about the history of medicine and ethics, and we write papers and we discuss them. And it was an in-depth, insightful meeting for two and a half days.
Okay, and I have questions for Mr. Bell. You made 2 statements that I'd like for you to expound on, which are confusing to me. And these involve your characterization of Dr. Tickner. And I'll quote, if I am correct, 2 statements. You said that Dr. Tickner has no particular talents based on his resume, end quote. And the other quote was ambiguous statements by Dr. Tickner. And I need further clarification on what you base those statements on.
All right. The administrative law judge describes in his proposed decision the ambiguities involved. He points out that the patient did present with stories of drug use, which he presented to this physician earlier than he did to your boy, and that he feels that essentially the doctor has integrated his understanding about the role of drugs in the practice of medicine. That is far short of saying this person, by reasonable scientific cause, did this because of that. He does not say that. In fact, he doesn't even offer a diagnosis. It's quite astonishing to me how one can go see a psychotherapist for a matter of years, especially one involved in a forensic process like this, and end up without even so much as a diagnostic hypothesis. No, this was industrial medicine This was sent by a lawyer to somebody who is in the business of getting people their licenses back. Very cursory. This is a profound problem. Results in 2 hours of history taking. No psychological testing. No instruments used to assess personality structure. No instruments used to determine whether or not there may be an underlying problem. He does refer, apparently, to Mr. Cosgrove as he should consider narcissistic personality as a problem. We just don't know what he came up with. I think he's an unreliable informant in this process. And I presume if he could justify, first, if he could clearly make the statement that as a matter of medical reality or plausibility, that this reasonably bright, smart, attractive person stepped entirely out of category or out of type and did these acts, and I can attribute it to his daily use of methamphetamines. He doesn't say that. And as we all know, people do sexual acts you see in these cases for reasons quite apart from drug use. And I ask you to consider if that's a possibility. And if you're not sure, then you mustn't decide that it's a truth to be accurate.
But again, you make, and I don't know if you've answered me,
Well, that's
no particular talents based on his resume. I'm not sure if you're...
Well, the talent I point out is that there's no demonstrated history of being able to make diagnostic predictions of future dangerousness, which is the big thing in psychotherapy. There have been rafters of material written about whether psychiatrists can predict future reoffenses of criminals. And there is no body of literature establishing that. And I saw nothing in his resume indicating that he had written or published on that subject, been subject to peer review, or held himself out as an authority on that subject.
And the final question regarding that, and I'm permitted to ask this, was Dr. Tickner given some instruction about what was expected of him in supplying the information for the hearing?
That is outside my knowledge, sir. I don't know. For Mr. Cosgrove might say.
Okay, thank you.
Anyone else?
I have a brief question for Dr. Bishop. You alluded to the fact that he had taken a PACE course. It looks like a PACE boundaries course. Was there ever a full PACE course? The full diagnostic personality and clinical knowledge course, which is quite extensive. It's more than a 2-day course. I believe it's a month or something.
So like a clinical competency course?
Right.
No. Well, there was an evaluation by, I did take a clinical competency course. I never submitted any information. It wasn't really relevant at the time, last time. So, but I think I can submit it if you guys still want to see it.
Thank you.
Anybody else have any questions?
But I'd be willing to attend any kind of course like that. In fact, I sort of plan to, as a condition of reinstatement, if I were given the opportunity. I think it would be good for me to be sure that all the areas of medicine are covered, that I feel confident and competent to be able to do that.
Thank you.
All right, thank you very much. This matter will stand submitted and we can go all forward.
Thank you.
We're now going to go into closed session.
Thank you.